This is Paul Turner, the Immigration Barrister at Imperium Chambers. Good morning, and I hope you have a happy start to this week. The Home Office has issued new guidance on continuous residence and what you need to qualify for indefinite leave to remain or settlement in the United Kingdom. This is one of a couple of videos. The next one's coming out tomorrow on this subject. There are a lot of routes depending on the facts of each case, so please feel free to contact me for more detailed advice. There's nothing worse, in my view, than spending thousands of pounds on an application that was bound to fail or was made too soon or made on the wrong form. The Home Office issued new guidance on continuous residence and clarified whether or not what you needed to do to get indefinite leave to remain and or settlement. It's the same thing really. However, I've decided to set out some general guidance, but I would really recommend professional advice if you are going to make such an application so you don't get caught out or lose and waste a lot of time, money and stress. As I said, there are a number of routes. In fact, there are a lot of routes, and there are some important things to watch out for, which I'm going to flag up hopefully in this video. Let's start with long residence, as this is the most commonly asked question. I've been here for 10 years and do I qualify? There will be a separate video on some problems that have occurred for the 10-year route tomorrow, but generally for long residency you will have to have been in the United Kingdom lawfully, and this can include short breaks, as long as you've entered with leave and have leave. This was made clear by the Court of Appeal fairly recently in the case of Hoque. What this means in practice is that if you have not acquired 10 years leave and your leave ran out, even if you made an application within 28 or 14 days, if you are not then granted leave, then your leave is broken. Your Section 3C leave doesn't continue. However, if you were granted leave, and as long as the gap or breaks in your leave are not over the limit, or there are exceptional circumstances, you should be fine. Turning to the different routes for settlement, some of the routes that are covered are skilled worker, Tier 2 Minister of Religion, Tier 2 sports person, representative of an overseas business or media representative or even sole representative, UK ancestry, global talent or Tier 1 exceptional talent, innovator, Tier 1 temporary worker, and that includes someone that's on an international agreement worker or a private servant in a diplomatic household. Now, what does continuous residence mean actually in practice? What actually is continuous residence? Does it mean you have to be here for every single day? Well, no, but there are limits. The applicant must show all of the following in order to qualify. Otherwise, they're going to fall foul of the relevant rules. They must have lived in the United Kingdom with relevant permission. Their residence must be lawful. The relevant period for pretty much all of the above categories is 5 years, apart from a number of quite notable exceptions, which can be used to the right advantage if you're thinking of coming and settling in the UK. Global investors and innovators only have to wait 3 years before they can qualify for settlement in the United Kingdom. Even better news is for the people that have no period of residence, and this includes dependent partners of overseas representatives, dependent partner of someone with British ancestry, and child dependents. For them, they can acquire settlement without any length of period of time. Now, turning to periods of absence. Crucially, they should not have been absent for certain periods of time. Not more than 180 days in 1 year is the general rule. For overstaying, it can be 28 or 14 days, and this will be a subject of another video. And given that we're in the COVID pandemic, you can disregard, and it's in the rules, any period of overstaying between the 24th of January 2020 and 31st of August 2020, where you may have overstayed. So that's another concession due to the coronavirus pandemic. This is some general guidance. There are exceptions, such as if you're subject to a deportation order or you were in prison, and there may be exceptional circumstances that mean that you still qualify for indefinite leave to remain. Suppose you were abroad and you couldn't get back because of an accident or an illness or some other compelling circumstances, you may still qualify. So if you are thinking of going for indefinite leave to remain, bearing in mind the penalties of being refused, it's worth getting professional advice. If you have any doubts about this matter, please get in touch with me and I'll be more than happy to help. I hope you're well. I hope you're staying safe. Thank you very much for watching this video. This is Paul Turner, the Immigration Barrister at Imperium Chambers.